Dear students, GPS CLAT Academy at Gyanodaya, a senior secondary school at Sikar, supports its students in their CLAT preparation. We have started a lecture series which will be delivered to you on a daily basis on YouTube.
Prime Ministerial system of government in which the cabinet headed by the chief minister or headed by the prime minister at the center wields the real power. Now, governor, as per the Sarkaria Commission report, is supposed to be the mentor and the friend and the advisor and philosopher and whatnot of the state government. But it seems when there are different uh, ideological, different parties with different ideological backings and in the center and in the state, then usually the governance is not very smooth. Now this trend has started, and the governors of some of the states are a case in point. And in this kind of scenario, the Supreme Court uh, has laid down a timeline for the governors to act on the bills which are presented. In its judgment, also went ahead and fixed the timeline for the president. So, and that is criticized by some on the grounds that it is a case of judicial overreach. So, this is what primarily the article talks about. And if there are problems, then you can, if there are doubts or differences on whether or not a matter should be, matter raises a concern about some constitutional provisions on which the state should or not legislate, then the apex court has indicated that you should approach the Supreme Court for its advice under Article 143, which is the advisory jurisdiction of the Supreme Court. We have also seen that a governor cannot approach. In the previous article on the same issue, we have seen that a governor it does not have the power. The high courts don't have the power. Only the Supreme Court has the federal court. The Supreme Court only has the power to give advisory opinions. Right? These things we have seen in the past also on the past article, which we have discussed on the same topic. Right? So let us come to the questions. Yes. So this 16th question, there is a problem with this, so we will not stay on this. 17th question, Governor of State why refers a controversial education bill to the President? 7 months later, the state receives no decision or explanation from the President's office. What is the likely constitutional outcome in this case? So, controversial education reform bill 7 months later receives no decision or explanation from President's office. So we know that in this case, what is to be done? In this case, the President has to basically give reasons for this thing. So the clear-cut case is that the educational bill was referred to the President, and it was first reserved by the governor for consideration of the President. The President kept sleeping on it. Now, what is the new dispensation? If the time is exceeded, then the President has to give the reasons as to why it took longer time. And those reasons, what is the utility of those reasons? What is the utility of the reasons? The reasons basically streamline the process and bring accountability into it. Because if the reasons are not there, then no further course of action may occur. If the reasons are absurd, then once again you can approach the courts for suitable directions. So reasons bring accountability. That is why the reasons are required. Reasons insisted upon. President is immune from time-bound directives. Time-bound directives. President is immune. Yes, President is personally immune, but the central government is not immune, right? Governor's delay nullifies the referral. No, the referral cannot be nullified. That is not written in the paragraph. President's office must now provide written. Yes, after the judgment, they have to provide the written reasons as to what is the cause for delay beyond 90 days. State must wait indefinitely. That is not what is there in the paragraph. Come to question number 18. State, is that clear to you? 17? 17 is done?
Yes.
It's done. A state legislature passes a controversial land acquisition bill. Civil society groups approach the High Court seeking a pre-enactment review. Now you know that you can't approach the High Court, right? Presidential reference has to be only in the Supreme Court. It can't be in the High Court, and only by the president. It can't be by the governor, right? So I need not. High Court may not opine on the constitutionality. High Court cannot opine. High Court doesn't have the jurisdiction to opine. Then we come to a governor reserves all state bills. Now you can't do that indiscriminately. You are being arbitrary. Governor's blanket referral is erroneous, undermines federalism. You can't do that. Whatever comes, you keep it on your table and keep sleeping on it. That is not the constitutional scheme. It's once in a while if in a term one or two bills are maybe objectionable, then those bills may be referred. It is not that lock, stock, and barrel all bills reserve or send back or refer to the president. No, this is not done. This way, how will you run governance if this kind of thing comes along? Now, please come to the next one, legal reasoning. Uh, this thing on adoption. So basically, this article, raises a few propositions. First proposition is that when the what happens when the institution's rules are silent? Then in that case, since the government is involved in establishment of the institution, the civil service rules will apply. Although the institution has autonomy, the government has granted it autonomy for purposes of excellence, the article says so. And from the state government interference in its internal affairs as well as from the union government's interference. Uh, the, the IMs have that kind of privileges. For that matter, all national institutes have that kind of privilege. Even National Law School has that kind of privilege. So they want minimum interference, maximum autonomy and accountability. That kind of arrangement they have worked out for the national institutes of importance. And here a case has arisen where the rules of the institution are silent. And the court has clarified that where the rules of the institution are silent, then the civil service rules of the central government would apply. This was as per this is provided in the um, there is this is provided in the 1972 rules, uh, where it says that central civil services rules are applicable where the institution's rules are silent, right? So that is one part of it. Then second part of it, of course, the court has also dealt with the 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 constitutional issues. Also, the court has opined on them. But the ratio decidendi of the case is basically that since there are civil service rules which are in operation, and since the institute's rules are not there, are absent, therefore the civil service rules will apply. The court has made several other observations as to uh, maternity leave being a matter of right and not a matter of discretion in the authority. So those kinds of things have been stated. Now, this article is a amalgamation of two articles on the same or related subjects. Therefore, I clubbed the two articles together and then put them into this. The second fact situation which is elaborated is which is taken from another source. Basically, it lays down the proposition that uh, uh, in matters of adoption, basically certain rules have to be followed. It's not that you approach an adoption agency and the agency says, "All right, I'll help you get a very intelligent child or the child with this kind of you know these kind of qualities and all that." It is not permitted. What is permitted is that the benefits or to the child come first, and the choices of the parents come second. The public interest is in ensuring the welfare of the child. Therefore, they have this system wherein they would first want to place hard to place children or uh, children who have special needs. Those are the children they prefer for placement first, and they follow a sort of seriatim order in which they want to place the children. And you can't jump the queue. You can't do cherry picking. That kind of things are not possible. Uh, and then the court has also made an observation that there is no fundamental right to adopt. So that kind of thing is there. Article 21, Article 14, you can't build an argument based on. Just give me 1 minute. It has started what we call as the sandstorm has started. So let me close the windows of my office. Otherwise, everything will be under sand. So the court says that look, the welfare of the child is paramount, and we will give importance to the requirement of the child rather than the requirement of the parent. And then there are some passing observations on the delays that are there in inherent in the system. And then I think that's it. That is all that it says. Of course, it also talks about the if you have to. There is a mention in the article that earlier even couples with 4 children could take another child in adoption, but subsequently this number was brought down to 2. And in this case, interestingly, the court has directed the authority to use one of the rarely used provisions in the Act, which basically says that you can take a liberal view in special cases. And here, the special case is that 2 children are already special needs children, therefore, they wanted a third child, and which is denied by the authority. The High Court says that no, you have the power, you exercise your power and issues a direction to that effect. So, this is what this article talks about. These are few of the propositions that the article talks about. Now let us go to the questions. Let us see how the questions shape up. Prakash and Nisha, I'm on question number 20. Prakash and Nisha, a newly married couple, want to adopt a child. They approach a private adoption facilitator with a request for adoption of a child whom they have already identified. That is not permitted. That we have already discussed. That kind of thing is not permitted. Facilitator promises to find them a healthy child quickly. Whether the couple are entitled to adoption, they may be entitled to adoption. Yes, they are entitled to adopt because it is not written that they have more than 2 children, in which case that disentitlement would come into operation. But they can't adopt like this. You have to follow the procedure, and we have discussed what is the procedure. Number one, you are in the queue. Number two, you have to prioritize the needs of the children for placement rather than needs of the parents for obtaining the placement. So that kind of thing is there. So none of the above would be the correct answer, huh? Because the answer is couple may be granted the adoption of the preferred child preferences are not the rule. Couple has wait for their turn. Of course, they have to wait for their turn, but it is only half the answer. The question is whether they are entitled to adopt or not. That is the question. The couple has to get the adoption process approved by court. Says this is neither here nor there. This is a distractor. So none of the above would be the correct option. Please come to question number 21. Kamla, an employee at a private university. Now this is private university. That university is a public university. This is a private university. There the civil service rules apply. Here the civil services rules don't apply. Therefore, whatever is the rule of the university that will apply, and that rule may be contradictory to the rule of the university. Is that clear to you? Yes or no? That is a public body. This is a private body. So the private body rules would apply. All right. That may be different from the rules of the public body. Is that clear to you? Yes, no, indifferent.
Yes, sir.
Yes, very good. Then please come to the 22nd question. Suraj and Meena have 2 biological children. Apply for adoption of a third child. Now they have 2. They are applying for the third one. This is prohibited by the new regulations in 2022. They request an infant, but due to updated adoption, they are informed that they can't adopt a child. In a writ filed by the decide the couple, there is no entitlement because under the under the 2022 rules, they have reduced the number from four to three to two. That is how the reduction has taken place. So there is no question of any adoption right vesting in them after the 2022 regulations have come into existence. Please come to question number 23. This is 100% correct, so I need not dwell on this. 24. Ravi and Anju applied to adopt a child under adoption regulation 2017. At that time, 4 were allowed. Their application is finalized and adoption is also granted. All right, now you see, adoption is granted. This makes a difference. Decision is taken. You are allowed to adopt. The letter is issued. Then they say they already have 2 children. Meanwhile, 22 regulations come into effect, limiting their options only to 2 children. The authority revokes their application. Now they say that no, now we will not allow. But the problem here is they challenge, arguing that the authority revokes their application. They challenge this change, arguing that the new rules should not apply to pending applications, whether the application may be granted. Now you see, here their application is finalized and adoption is granted. Thereafter, the new rules are coming into existence. Please look at the date very carefully. So what I was saying is that the application has already been granted. Once the application is granted, once the decision has been taken, thereafter they can't say and turn around and say that look, a new rule and regulation has come into existence. Therefore, we will not allow it. That option is not available with them at present. Is that clear to you? Vested rights, once it is finalized, it is granted in your favor before the 2022 regulations come into force. Once the decision has been taken, the rights becomes vested. The right becomes vested in you. Then you cannot say that look, 2022 regulations will apply. Had the decision not been taken, you follow? Had the decision not been taken, the position would have been different. Then the application would have been pending. To the pending application, 2022 regulations would apply. But once the decision is taken, then how can you turn turtle the decision which has been taken and apply the new regulation? The decision has already been taken under the old regulation and finalized also, adoption also granted. Then you won't be able to take this route of the new legislation which has come into existence, right? Could you hear what I was saying? Because my screen continuously flickers, it gives me a lot of annoyance, but I can't do anything about it. Did you hear what I was saying?
Yes, sir.
Were you hearing? All right, you are hearing. Very good. So now I think this is complete.
The lecture series revolves around discussion of mock papers. You can request us for the concerned mock papers. If you intend to join us in our daily discussions, you are most welcome.